Hey guys, how's it going? Welcome back to part 3, or I guess if this is your first, what is my collar doing? If this is your first time viewing these videos, welcome to part 3. You should go back and watch parts 1 and 2, but I think most of you will probably be returning viewers. So this is part 3 of the Google lawsuit, specifically the class action lawsuit filed by James Damore and others, right? Namely, Goodman is the other representative of the class, filed on behalf of basically conservative-leaning Caucasian males, okay? Filed against Google for unfair discriminatory practices in violation of California law. In the first video, we went through the facts section. The second video, we started into we finished up the facts section and then went into the class analysis portion. And now we're going to move into the legal causes of action and look at the nuts and bolts of the law in California. Because the real question is, obviously, does California employment law protect Caucasian males who have a right-leaning political affiliation? And at first glance, because it's California, you probably think, well, no, they're screwed. But that might not be the case. There aren't a lot of lawsuits. I shouldn't say there aren't a lot of lawsuits. Okay, there aren't a lot of authoritative lawsuits, meaning going up to the appeals and Supreme Court level, analyzing this question from a place of privilege, be it heteronormative privilege, if we can use some buzzwords, or be it Caucasian or white privilege, or male privilege, patriarchal privilege. If that's your cup of tea to identify it that way, go ahead, buddy, I'm with you. However we determine or define this, we hear a lot of cases because typically, historically, the whole idea was that there were people discriminating against minority or underprivileged classes, whatever that may be. And in different states, that's going to be different, right? In Mississippi, that's probably going to be different than in California. Historically speaking, right? Hopefully we're coming to some level of parity where everybody is basically equal at first glance and we judge them based on their performance, right? That's the idea, is that a person, whatever shell they may be wearing, is completely irrelevant to their ability to perform work. And all we care about is, do they make us money? In the long run, I don't care what any person looks like. Do they make me money if I'm hiring them? And if they make me money, great. If they don't make me money, not so good. So, I have forgotten a critical element. I need to lubricate this video a little bit. And I'm working on this wheat whiskey here from the 45th Parallel Distillery. Still not a sponsor. If they're looking to remedy that, send me a message, guys. But that would be fun. Anyway, they make very good whiskey. I like it. I've had their wheat whiskey and their bourbon, and I have a bottle of rye, which is coming up. But tonight's going to be the wheat whiskey because I need a little bit of fire going down the tube. And there it is right off the start. I like it. It's good stuff. It's really growing on me from my first taste. And I'll be sad when the bottle is gone. So anyway, let's dive into this. And I'm going to have to rely on you guys a little bit to remember or to go back and dig through the facts. Because what I don't want to do, right, they've laid all this out. And I don't want to go back and be scrolling up and down and trying to cross-reference this stuff with every cause of action. So far, their fact section has been Obviously slanted. Like, remember, this is a legal complaint. What they're trying to establish is a case most favorable to them. There's all sorts of techniques for doing that. The person who drafted this document is very good at it. They're very competent. They have laid out a reasonable scenario of facts. We don't get the impression that a bunch of stuff is missing. We don't get the impression that they're lying to or misrepresenting the court. They may be doing those things, right? And until we see Google's response, excuse me, until we see Google's response, we have no way to know. All we have is what's in front of us. And that's this document. Google may respond and have a very favorable document. I assume it will be extremely well drafted and thorough and will go through and try and debunk every single point made in this document. At first, I wasn't sure. I thought Google might just try for summary judgment or dismissal for failure to state a claim. After looking at the law, which I'm going to show you in a minute, I don't think that's the case. I think Google will have to actually fight this. I think it may survive summary judgment and it may survive into, survive dismissal and move into an actual action. It's impossible to know. There are people involved in this and people are largely irritating and unpredictable. So you get a judge on the wrong day with the wrong attitude, and they rule in a way that you don't expect. I don't know. Happens all the time. All the time. That's the job of people like me, is to influence that decision and sometimes to make them make a decision that is not what other people expect, right? Because if everything was as expected, you wouldn't ever need a lawyer because everything would just go the way it's supposed to. But that's not how the law works, and we have a weird sort of system built on that, and that's cool, I guess, because it employs me. So, without further ado, the first cause of action is a violation of California Labor Code Section 1101. So this is by the plaintiffs on behalf of themselves and all of the classes and subclasses, blah, 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 and against all of the defendants being Google itself, and then 10 unnamed executives and board members. They're unnamed because they're not entirely sure who they are. They'd be looking to discover this during discovery and then would name them at that time, presumably. So, but this is against all of them. All of them are involved in this. So, of course, plaintiffs repeat and incorporate each paragraph above as if fully set forth here. I hate having to put this line in a document because, of course, you repeat and incorporate everything you just said into this section. If you didn't, why would it be there? Dumb rule. 208. The employers may not discharge or discriminate against an employee for engaging in political activities or the exercise of any rights afforded him. California Labor Code Section 1101 prohibits employers from making, adopting, or enforcing any rule, regulation, or policy that forbids or controls or tends to control their employees' political activities. Let's look at it. Here we go. Hopefully you can read this. I made this document. I can zoom in a little bit. That might help. I know it's kind of hard to read, but what do you do? So, Section 1101. No employer shall make, adopt, or enforce any rule, regulation, or policy. Okay, so there has to be a rule, regulation, or policy. But any rule, regulation, or policy, that means it can be unwritten, it can be presumed, it can be merely an effect. It does not have to be an actual, laid out policy in the handbook that we discriminate against these people here. That's not how this works. Anything can become a rule if it is put into practice. It does not, like I said, it does not have to be codified specifically. They can be inferred or implied. So, A, forbidding or preventing employees from engaging or participating in politics or from becoming candidates for public office. That seems pretty broad. Controlling or directing or tending to control or direct the political activities or affiliations of employees. So the reason I bring that up is just to point out that they did not quote it directly, but they accurately paraphrase the statute. That's the whole thing. That's all of Section 1101. Very short, 2 parts. You can't stop them from engaging in political activity or becoming a political candidate. And what was that second part? You can't control or direct the activities, the political activities. So you can't stop them from doing what they want to do, and you can't sway them. Well, you can't control their decisions in the political realm either. So the obvious subversion would be no. We force them all to be Democrats, therefore we're not stopping their political activity, right? That'd be the joke there. And California might not be much of a joke, right? So anyway, California Labor Code Section 1105 states, nothing in this chapter shall prevent the injured employee from recovering damages from his employer for injury suffered through a violation of this chapter. This isn't important for us, but just some background on why that's in there. It's because Section 1103 makes this an actual crime. Okay, so if you are an employer and you engage in a violation of this chapter, it is a misdemeanor. It is punishable by up to a year in jail and up to $1,000 fine. So in some statutes, when you have a statute of criminal liability, it doesn't automatically create civil liability or a civil cause of action. So they are quickly pointing out and dispelling that idea by stating that 1105 says, nothing prevents them from recovering damages for an injury suffered in this chapter. So though it's punitive and criminal in nature, it does allow use of these chapters and this sections to create a civil cause of action. This was upheld in a case. I don't remember the case name off the top of my head, but I can find it real quick, and it might be funny. Let's see. It was... Where'd it go? Where'd it go? I should have just looked this up. All right. I don't have it. I thought the case name was literally boring. That's one of the cases in here. I thought I had a joke, and I don't have a joke. Sorry. Big foul. Big foul on my part. Anyway, I'm not going to waste time looking for this. It's not important. Take my word for it. Or look it up yourself and prove me wrong. Where did we go? So anyway. So that's the purpose of quoting Section 1105. They can use civil liability even though these are criminal statutes in a way. So upon violation of the section preventing employers from controlling political activities of employees, the employees have a right of action for damages for breach of an employment contract, and they cite Lockheed Aircraft versus Superior Court of Los Angeles. This is the most cited decision in this case. It's the foundational decision for what is a employment activity. Real quick, let's just take a look at the intro. I'm not going to go through this whole case. The intro is sufficient. So this is 1946, right? So they're making weapons. Lockheed Aircraft Corporation, hereinafter called defendant, was sued by 18 of its former employees, hereinafter referred to as plaintiffs, claiming they had been wrongfully discharged pursuant to rules adopted and enforced by defendant regulating and controlling their political activities in violation of Section 1101. Fun fact, this statute was enacted in 1917, and it was codified in its current form like 1937. So yeah. So defendants demurred to the complaint having been overruled. It answered, denying the existence of the rules and regulations above referred to, and alleged by way of affirmative defense that it was engaged in the manufacture of airplanes for the federal government under contracts which required it to protect its plans from entry by persons of unknown loyalty or suspected disloyalty to the United States, that it did not have sufficient information and belief as to the respective plaintiffs to satisfy itself of their unquestioned patriotism and loyalty, which is a cool, or not cool, depending on your perspective, artifact of like immediate post-World War II and through the Cold War aspects of American history, right? The idea that if people weren't patriotic or loyal to the country, they could be a danger because we were at war. Since we've spent the past 70 years not really being at war, most people don't realize like how important this was. It was important enough for wheelchair-bound FDR to throw Japanese Americans into concentration camps. And just remember that history regards him as one of the greatest presidents, if not the greatest president of all time. He separated people by race and put them in camps while we were fighting Hitler. He also took their land and gave it to white people. Best president ever. Just remember that. FDR, not good at standing, but good at putting people in camps. So the defendant here seeks to prevent further proceedings in connection with the taking of the deposition of its president, contending that Section 1.1, which underlies plaintiff's actions, is unconstitutional and therefore they failed. They failed in all of this, but here's the ultimate thing. They failed in holding this unconstitutional. They failed in striking down the statute, but they did not fail in the fact that they were allowed to fire people for being disloyal, because political activity, according to the court, was political activity for a functional government, and the overthrow of said government is not considered a valid political activity that must be protected. That's a summary of Lockheed. I'm not going to go through it all because we're going to get the relevant snippets from Lockheed in this guy, which I've highlighted to make things easier. And this is a memo from the Attorney General of California in 1986, and I'll talk about that in a minute. But we'll get the relevant parts of Lockheed there. So just keep in mind that this is the landmark foundational case for this statute. They were not able to defeat the statute. The statute is absolutely valid. It has been since 1946, and it has been broadly interpreted to encompass political activity of all stripes. So, except for stripes which advocate the overthrow of the United States government. Plaintiffs and all members in the political subclass engaged in protected political activity. Plaintiffs and the political subclass members expressed their political viewpoints, and as a result were discriminated against throughout the respective class periods by Google, which does not share their political views. And taking the facts section of this document at face value, absolutely. It's unquestionable that they were discriminated against based on their political views until we get something from Google stating an otherwise valid reason. But it looks like their political views on gender, on race, and mind you, these guys were not advocating for discrimination against other races. What they were advocating for, at least specifically Damore, they're advocating against discrimination against Caucasians in favor of minorities, which would presumably be a violation of this very statute, okay? So they're not advocating that other people be treated poorly. They're literally advocating for the equal treatment of everyone on the basis of race, gender, orientation, skin color, national origin, all of those protected statuses. They're not advocating for other people to be less. They're advocating for white people to be equal to these other people. You may think they have nefarious intentions. I don't care. Go ahead, think that. I don't hold much opinion on their intentions. What I'm concerned with is the law, and the law in California says you got to be equal. So, as a direct result of the aforesaid violations of law, as well as the job retaliation set forth herein, that's going to come down later, plaintiffs and political subclass have sustained and will continue to sustain for a period of time in the future compensatory and general damages in an amount according to proof at the trial of this action. Absolutely. They all lost wages, and in doing so, they had to seek new employment. They potentially have had their names marred by being terminated from Google for having untoward political affiliations or perspectives, and any referencing employer. Google may have tarnished their names for them, intentionally or not. It doesn't really matter. As a direct and proximate result, so the direct result of Google's actions, and then the proximate result, which means that there wasn't something intervening in that direct result, Google's willful, knowing, and intentional retaliation. So what they're doing here is setting up, that this wasn't an accident. It was intentional. They can't, Google can allege that it was all a big mistake. It's going to be tough because they smartly have an internal social network that allowed all of their stupid, moronic managers to publish their stupid, moronic violations of law. And even if they're not violations of law, they're unpalatable views for the public. And should a lawsuit ever come up, all of this stuff is going to be in public display. Anyway, as a direct of their willful, knowing, and intentional retaliation, plaintiffs have suffered and will continue to suffer emotional and physical distress and injury, stress, humiliation, anxiety, depression, and other employment benefits and job opportunities in an amount to be determined at trial. And though it's worded fun, they have the Oxford comma here, so we don't get to infer that stress, humiliation, anxiety, and depression are employment benefits of Google. I almost wish they would have left off the Oxford comma, despite me being completely in favor of it, just to make that ambiguous and funnier. Get funnier. These actions of Google were so cold, callous, and reckless. See, they don't have an Oxford comma here. They're so cold, callous, and reckless as to be malicious. It's a weird way to state that they were malicious. Plaintiffs in the political subclass are therefore entitled to an award of punitive damages in an amount to be determined at trial. Because this claim arising under California state law is a matter of public concern and affects the public at large, plaintiffs in the subclass or in the class and subclasses pray for attorney's fees and expenses pursuant to Code of Civil Procedure 102.1.5. And this is where the real winners come about in class action lawsuits, and that is the attorney's offices. Okay, so if the attorneys are successful in getting this suit, in winning this suit or settling this suit, the attorney's office that is running this case is going to get a massive amount of money. A massive amount, because taking this suit to trial will be horrendously expensive. I just mentioned that Google has an internal social network. It covers 80,000 people. They're going to go back at least 3 years, and some poor schlub is going to have to look through every single one of those messages to try and find anything that leads to culpability. They have some screenshots in here. Presumably, there would be numerous other examples from this internal messaging forum. And it's going to be some intern or temporary worker's job, or paralegal, I guess, to go find them. And that's going to cost a fortune. They're going to have to hire a lot of people, and they're going to have to do it in California, where it costs a lot to hire people. So the real winner will be the law office. They'll make a boatload of money charging fees for that. If they, assuming they win and are awarded fees. Happens a lot in class actions. So the second cause of action is violation of Section 1102. Very similar. We'll read their thing and then I'll show you the statute. 1102 makes it illegal for an employer to threaten employees with discharge as a means of coercing or influencing employees' political activities. Here's the snippet. No employer shall coerce or influence or attempt to coerce or influence his employees through or by means of threat of discharge or employment, discharge or loss of employment. See the danger of Zoom. Let's see, 130. Okay. There we go. The danger of loss of employment to adopt or follow or refrain from adopting or following any particular course or line of political action or political activity. Right? You can't threaten someone and tell them to go to a rally. Interestingly, Wells Fargo actually does this in Minnesota. Not sure if it's illegal here because I haven't had cause to research the issue. But when I worked there were certain political activities that Wells Fargo required its employees to go to, despite, their political or religious or personal beliefs. So that's interesting. Didn't happen to me. I have no cause to sue Wells Fargo, though I did work there. I have cause to laugh at Wells Fargo for getting tagged for opening up a bunch of illegal credit accounts, because there were people who reported that illegal activity, and those people were ignored. In 2005 and 2006, you could have put a stop to it, and you didn't. Instead, you gave bonuses to the people who did it. Good job, guys. Anyway, so again, they incorporate Section 1105 to state that there is a civil cause of action here. And again, they're going to quote Lockheed. Upon violation of the section preventing employers from controlling political activities of employees, employees have a right of action for damages under Lockheed. Plaintiffs in the political subclass engaged in protected political activity. So they claim. Plaintiffs and the political subclass members express their political viewpoints and as a result were threatened and coerced throughout the respective class period by Google, who does not share their political views. Now, I'm going to finish this section, this cause of action, and then we're going to jump into this memo, because this is where we talk about what it means to express a political viewpoint and what is protected political activity. As a direct result of the aforesaid violations of law, as well as the job retaliation set forth herein, plaintiffs in the political subclass have sustained and will continue to sustain for a period of time in the future compensatory and general damages in amount according to proof at the trial of this action. So they're not going to lay out ahead of time how much this is worth. We can presume it's worth a lot. And then, the amount of people involved and affected is going to impact, the number of people who have been think about this. A fact finder, either a judge or a jury, is going to have to figure out all of the people fired who are members of the class, what their salaries were, or at least an average of those salaries, or a presumed average of those salaries. And they're going to have to tally that up. Then they're going to have to figure out who was bypassed for promotions, which is an intangible number when we think about it. But there could actually be, some quantifiable way. When we have one of these dummies on there saying, I will not hire a person who supports Donald Trump, for example, then we can just look at the number of job postings that went up. We can look at, they can actually probably through discovery find the number of applicants for that job posting. They could maybe even identify their political beliefs based on a class, or they could just presume that at least one person was passed up in all of these things. Who knows how the judge will do it? But there are lots of ways for them to tally up a lot of numbers here, and it's going to rely on discovery. So they're not going to set forth at the onset how much this is worth, because you don't want to hamstring yourself and say this is worth $20 million if it's actually worth $70 million. And they don't have any reason to assert the damages at the onset. So as a direct and proximate result of Google's willful and knowing and intentional retaliation, plaintiffs have suffered and will continue to suffer emotional and physical distress and injury, stress, humiliation, anxiety, depression, other employment benefits, and job opportunities in an amount to be determined at trial. These actions of Google were so cold, so callous. This is a copy-paste, right? Callous and reckless says to be malicious, entitled to punitive damages, and, of course, attorney's fees and expenses. Same thing, and they're really, really similar, right? These two snippets, these two sections, 1101 and 1102, extremely similar. Same heart of the statute here. So let's look at this. So this is a letter from the Attorney General of California in 1986. And the question was, Do Labor Code Sections 1101 and 1102 prohibit a private employer from discriminating on the basis of homosexual orientation or affiliation? I lay this out because this is not a slam dunk link for Damore and Gudeman against Google, right? This let's be honest about what this document is. This document is the California Attorney General's opinion about specifically homosexual people engaged in speech relating to their homosexuality or their sexual orientation. Specifically, I shouldn't just say their sexual orientation, their homosexual orientation or affiliation. The counter argument would be that this does not apply to people with cis, hetero, normative sexual orientations. Although I don't think that's going to be relevant when we start getting into what this text says. Okay, so here's the conclusion. Labor Code Sections 1101 and 1102 prohibit a private employer, and this is important, it's got to be a private employer, or this applies to private employers. This definitely applied to public employers, but they're making sure that this does apply to private employers as well, from discriminating on the basis of homosexual orientation or affiliation. Okay? But here is where we start to get into the relevant sections that are quoting Lockheed and other cases that either influence Lockheed or cited or cite to Lockheed later. Sorry. Oh, excuse me. So so here's what I was talking about. The prohibitions were originally enacted as a single section in 1915 and were recast by the legislature in their present form in 1937. So at the time of this drafting, this statute has been unchanged for 49 years. And it remains unchanged today, right? Here they are, if you can see this. There, boom, is the exact same statutes we just read. They have not been changed in any manner. So these things have been statutes for 80 years. 80 years now. Unchanged. That's powerful in a way, because statutes change all the time. Little edits here and there, clarifying, narrowing, tailoring the statute to match up with the legislative intent. It's extremely telling that in 80 years they haven't had to change these statutes. They haven't had to narrow the statutes. That tells you at the onset that these statutes are intended to be broad. The legislature has, this has routinely been decided broadly since Lockheed. That's 1946. So that is 70 years. 70 years of history that these statutes have been interpreted broadly and only expanding. And at every time a court take a moment here. Every time the court expands through the use of their judicial power the meaning of a statute, the legislature has an opportunity to cure that expansion by clarifying legislation and saying, I get how the court got to this ruling. We disagree. It was not our intent. Instead, we want it to say this. And then they go ahead and limit it and chop it down and tighten it up. They haven't done it. They've been ruling on these statutes for 70 years without a single word change. That's really important here, okay? Because 70 years ago, when they're ruling on this, 80 years ago, when they wrote it, when they recast it, and ultimately 103 years ago, when they first wrote the words. When they say recast, they mean they broke it into two sections, okay? They might have redone a couple words there. I don't have the initial text. I'm not going to look it up. But when they put the initial thoughts on paper in 1915, California is not contemplating sexual orientation at all. 1915, World War I. We've got Woodrow Wilson in office. It's looking like we're going to war. I think we entered the war in 1916. History buff, correct me on that. I know we're teetering on the edge of war. it starts to become important that political, the Great War, right? The war to end all wars. It starts to become important that political affiliations and voicing of political things are protected in this time, right? This is where Americans start to really diverge on a couple issues. Taking it in context, 1915, 9 years after the passage of the income tax. Something that had never been done before. Suddenly we have an income tax to fund some of this stuff. Anyway, you've got these protected categories that have been protected for 100 years. 100 years by roughly the same words. Certainly the same words for 80 years. And they've only expanded protection in that time. I can't emphasize that enough. Like, this is a rare find in statutory construction and interpretation. So, nerd out with me for a minute. Okay. The courts have usually interpreted the statutes as being intended to defend employees engaged in traditional political activity from reprisal by their employer. So going on, the Supreme Court commented that the statute concerned activities related to or connected with orderly conduct of government and the peaceful organization, regulation, and administration of the government. The sections protect, quote, fundamental rights of employees in general to engage in political activity without interference by employers. Okay? So the statutes were instituted, paraphrasing the next section, for the purpose that there would be suitable protection of health and safety, and so that peace and good order may be promoted through regulation designed to ensure wholesome conditions of work and freedom from oppression. The idea that an employer could force you into a political view and suppress your speech was oppressive. This is in 1943. We're forgetting the roots. Guys, we're forgetting. In the interest of political correctness, and I hate using buzzwords, right? So whatever you take political correctness to mean, its definition, it actually doesn't matter to the argument here. In the interest of whatever stripe of political correctness or social justice or silencing of opposition in general, whether you're a conservative and you want to shut Antifa down or Black Lives Matter, or you're the most bleeding heart liberal and you want to punch all the Nazis in the face, and you don't want any of them to speak at Berkeley, which is your mecca, it doesn't matter how you interpret my recital here. It used to be important that people could say what they want and not have an employer impact that. Now we want people fired for everything, which is just, if you took someone from 1945 and you put them in today and you said, this person wants to fire all the people who disagree with them, they just laugh because they had so many other things to worry about. I don't know. I'm presuming that, right? I wasn't alive in 1945, but the idea that, that you would have someone fired for peaceably advocating their position is kind of ludicrous in the idea of American history. It's what our country was literally built on. The fact that you could raise reasonable dissent to any idea, no matter how unpopular, racist, hateful, sexist, anti-colonial, pro-colonial, it didn't matter. If you could raise a reasonable statement without hurting someone, and I mean in the physical or economic sense, not hurting their feelings, if you could do it without causing actual damage to someone, then it was fine, and you couldn't be punished for it. Or I should say you shouldn't be punished for it, because there were punishments, and they got a lot of things wrong. Don't don't make me glorify the speech protection of this era. But the ideas of political speech being protected go so far back that the fact that we don't pay that any homage today is just, it's delightfully perplexing. So anyway, tangent off / end. The court first determined that the protection for, quote, political activities could not be narrowly confined to partisan activity on behalf of a political party. So it's not just being a, phone bank for a Senate campaign or House campaign or anything like that. Quote, association with others for the advancement of beliefs and ideas had all been held to be political activities. This is by the United States Supreme Court. The advancement of belief and ideas. That is so ridiculously broad as to be laughable when you start to think about it. That means that anything. Telling AARP to stop calling you because you think they're a bunch of commies is a political activity. We engage in politics all the time, and political speech is overtly and routinely protected as sacred in this country. Against this background of cases defining political activity in broad terms, the court concluded that the fight against discrimination on the basis of homosexuality was political in nature. This memo is limited to the issue of homosexuality, but I don't want that to be interpreted as the idea that this memo limits political activity to pro-homosexual speech. That's not what it's doing. In 1986, this is using the idea of a broad interpretation of the text to add homosexual activity and identity into the auspice of political activity. The language of this memo is broadening. The counter argument would be to try and limit this memo to homosexual activity and identity. That would be a very difficult argument to make in the context of the memo, but I want to be fair in the use of this memo. This memo is cited, by the way, in subsequent Supreme Court cases as being largely correct. They use this memo not authoritatively but informatively to kind of get an idea of what the prevailing thought was in how this should be applied to future cases involving homosexuality. We do not have it, of course, applied to a case analogous to what we have here with Damore versus Google, but the general and consistent idea is that these statutes are extremely broad in their protection of political activity so long as it isn't subversive to the function of government in the United States. And I'm talking like revolution and overthrow. Communism later would have been, the no word. But if we're talking about electing a person president, even if a lot of people don't like them, that's protected political speech, almost guaranteed. So I'm going to skip a bunch of this stuff. It's all gay stuff. Literally, it's all about gay stuff. It is obvious that the legislature has barred, for example, the discharge of an employee who openly declares himself or herself to be affiliated with the Republican or Democrat parties by reason of that party association. Next, political activities are not within the purview of an employer's legitimate interests, and that political activities or affiliations, whether private or public, should not be tolerated as the basis for employment decisions. Should not be tolerated, Google. Not very googly of you to overtly flaunt the law. You have a legal department, probably an overpaid one. They should have found this memo a long time ago. There's only a couple more quotes from this memo. 2 more, to be precise. So let's go through those. We can see that if an employer had a policy of discharging employees believed to be secretly associated with the Democratic Party, employees who were actually oriented in that direction would feel pressured to either declare themselves publicly as Democrats in order to secure the protection of Labor Code sections 1101 and 1102 for their political affiliation, or to declare themselves as Republicans in order to placate their employer. Those whose private orientation was toward the Republican Party would feel a similar compulsion to convince their employer of their orientation. So again, synthesizing orientation to mean both political and sexual. For the purposes of the statute, making the argument to broaden, again, the interpretation to include homosexuality. In doing so, he necessarily links homosexuality to political party for the purposes of statutory construction and interpretation, right? You can't argue that now this statute only protects gayness and doesn't protect, traditional ideas of political activity. You similarly would have a very hard logical argument stating that this only protects homosexuality and not any other sexual orientation, including heterosexuality. It's not really at issue here. I mean, they mention heteronormative sexual identity being discriminated against at Google, but I think the thrust of their arguments doesn't rely, or the thrust of their complaint and their cause of action don't rely on that. It's merely the fact of being right-leaning or conservative. The effect of the policy would be to force the company's employees into particular courses of political activity, irrespective of any preference to keep their orientation a private matter. And so, yeah, they're talking about, if a company had policies for or against a particular thing, people would either have to be silent and in the closet, so to speak, or they would have to openly come out of the closet, but coerced into towing the company's political line. And that's the root of the allegations here. That has been stated over and over in the facts, and taking these facts at face value, Google has violated these two sections overtly. So, I don't have any more case law on this. Really, it's Lockheed and then a bunch of cases about being gay. So there's not a lot to go off of other than the Lockheed decision. And the Lockheed decision strongly favors the idea that political speech, so long as it's for a functional government, is protected. Strongly favors it. And when I say there's no other cases to argue the contrary, there are none. No authority out there supports Google's presumed position based on the facts alleged at this point. Again, so this is important because this means that Google isn't going to have a legal argument. They're going to have a fact-centric argument. And if you have a fact-centric argument rather than a legal-centric argument, you're probably going to go past summary judgment. You're probably going to go past dismissal, and it's going to go to discovery. And at that point, Google is probably going to make a huge offer to Damore and Guterman and the class as a whole. Otherwise, this case is going to go on for a long time. It's going to be massively expensive. There's a high likelihood that Google loses, and their risk tolerance just may not be there to drag their own name through the public, to drag all of their discovery, potentially, or all of their internal message boards potentially get released to the public. And presumably, approximately half of Google's users are going to be conservatives. And if there's an open and overt discrimination against them, they might start using Bing or some other search engine. Who knows? So the third cause of action, this is where we get away from some of the statutory construction that's specifically laid out above. Oh, excuse me. It's late. I'm really tired today. I apologize. This is the third cause of action, workplace discrimination due to gender and or race in violation of the Fair Employment and Housing Act. So again, by the plaintiffs and all the classes against everybody. So at all relevant times, Google was an employer covered by the FEHA, and plaintiffs and the gender and race subclasses were covered employees. Whew. Google violated FEHA when they discriminated against plaintiffs in the gender and race subclass members because of their gender and or race by, among other things, taking into account gender and or race when considering promotions, failing to protect employees from negative comments made about Caucasian men as they protected members of other protected classes, and ignoring formal requests for redress from Google managers and the HR department. And this is bad. Let's go here. So I mentioned that Section 1103 makes this violation a misdemeanor. I'm not going to go through that. I mentioned it earlier. Here's the important part. Responsibility of employer for actions of agents. So, principal and agency relationships can be established under common law by showing that someone is an agent or is reasonably thought to be an agent by the affected party, or they can just be laid out in statute, like here. In all prosecutions under this chapter, the employer is responsible for the acts of his managers, officers, agents, and employees. That means everybody. Everybody, when we go back into the facts section and look at all the dumb morons who are out there stating openly their presumed violations of California labor laws, stating that they wouldn't hire these people based on their political affiliations because Google has fostered a echo chamber, a 80,000 strong echo chamber of people who believe that they're insulated from law by working at Google and that they can literally discriminate based on protected speech. Sorry, you're in California and you can't. And your legal department should have told you that. And they probably did, to be honest. They probably said, by the way, don't publish that you have a blacklist of employees. Like, go ahead and keep your blacklist on a notepad next to your desk. Don't publish that you have a blacklist of employees based on their political views, you stupid idiots. What were you thinking, and why Google didn't immediately take those posts down is baffling to me. Because, by the way, before we get a dumb counter argument, because we're going to debate both sides of the issue here, but we're going to do it logically. Let's see. Let's say that Google's argument is that the managers stating that they maintain a blacklist is similar political activity and protected speech. No. You're wrong. You can't... Yeah, speech that is a violation of the law, right, is not protected. Like, it's presumably not protected if it's specifically laid out and upheld over and over as a constitutional bar on this type of employment activity. You can't then state that their speech is protected political speech. It's not. Their speech by itself is a violation of the law. And I am a huge free speech proponent, right? I don't necessarily agree that this is the way the law should be. But importantly, this is the way the law is and has been for a really, really long time. And you morons should have caught this, and you should have clamped down on this. And Damore, assuming his allegations are true, gave you every opportunity to do so. He gave you every opportunity. He routed it through the proper channels. And by your stupid refusal, you probably have opened yourself up to even more liability. Blah, 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 direct and proximate cause, cold and callous, malicious. This is a copy pasta of the previous two sections. They're asking for everything. Damages, punitive damages, and attorney's fees. So next, workplace harassment in violation of FEHA by plaintiffs against all defendants. So this isn't on behalf of the classes. This is Damore and Gudeman specifically. FEHA provides that it is unlawful for an employer to harass an employee because of inter alia, the employee's gender and or race. They're incorporating the entire FEHA Fair Employment and Housing Act, which is going to be, it's too many different statutes to cite the specific ones. The general theme is that you can't harass an employee because of their gender and race. Furthermore, it is unlawful to harass an employee, 2 E's there, for informing internal management about possible violations of the law. And that's actually covered in a statute coming up, and we're going to get there in a hot minute. Google constantly treated plaintiffs in a discriminatory and harassing fashion after they reported labor code and California civil code violations, thus creating a hostile work environment. Again, assuming their fact section to be true, this seems very likely. The harassment was based on plaintiff's gender and or race. I think Google will argue against that and state, but I don't know how, because their other alternative would be that it was based on their views, which probably protected political speech. And their constant reminders to Google to not break the law by taking into account protected categories, giving underrepresented minorities and women special preferences when making hiring or promotion decisions. Any discussions to the contrary were ignored. Now, Google's tactic here, as best I can guess how they're going to address this argument, is that they're going to state that the Fair Employment and Housing Act was established to give underrepresented minorities a boost, an affirmative action, so to speak, right? The idea that they are protected and that white males are not protected by the Fair Employment and Housing Act. I don't know how this case is going to fly, or how that argument's going to fly, but it is a very good argument. It actually has Supreme Court precedent. Originally, the original applications of the 13th and 14th Amendments only applied to black people. They did not apply to anybody else in the earliest cases. We're talking right after the Civil War. Various non-black people sued under the slavery prohibition of the 13th Amendment and the Equal Protection Clauses of the 14th Amendment. And the Supreme Court basically said, no, it's reserved for black people who were held as slaves. They're the ones who need that equal protection. You don't get this equality because you already have it. You have the equality. They don't. It's protecting them. Now, those cases have been whittled down and questioned and refined. And now, the 14th Amendment is not restrictive to black people. It is expansive to all sorts of things. For example, like the gay wedding cake case that's going on in the Supreme Court right now is a Fourth Amendment equal protection case, expanding the traditional idea of who is protected under the 14th Amendment to hetero or homosexual couples, right, trying to get married. Or not trying to get married, but trying to force an artist to create something for them as a place of public accommodation. So, the 14th Amendment was originally restrictive. Now it is broadly expanding, constantly expanding. Almost every ruling under the 14th Amendment actually has expanded a previously known definition. So, arguing, Google will probably argue that these cases are intended for specific minorities, but when you start to discriminate based on race, you raise the scrutiny level, and I'll cover. Sorry to get jargony, but in the interest of time, I'm going to release another video on scrutiny and how it applies to statutory interpretation in the Supreme Court. But know that there are multiple levels of scrutiny that are applied, and when you have like a statute that is facially discriminatory based on race, for example, that statute, it gets strict scrutiny, because if you're discriminating based on race, it has to be for a compelling government interest. It has to be narrowly tailored to fit that government interest and go no further, because the idea that discriminating based on race under law has to be so closely guarded and protected that it has to be for these reasons. So if Google starts making these arguments, then the court has to start looking at these statutes in this way to determine if Google's right, and it changes the scrutiny level. And by changing the scrutiny level, you can really damage your own case. So they may make that argument. I don't think it'd be successful, but you never know, right? It's a judge. Google's conduct was so severe and pervasive that it altered the plaintiff's conditions of employment. Sure seemed to, from the facts section, right? Unable to get promotions, unable to move laterally in a lot of ways once political viewpoints came to light. Damore was fired 3 days after the memo, stuff like that. Google's treatment of plaintiffs caused them to consider the work environment to be hostile and or abusive, and a reasonable person in their circumstances would have said the same. Plaintiffs made it clear to Google that such harassment was unwelcome by reporting it to Google HR directly multiple times. However, Google failed to act. And, failure to act it's not always a cause of action. It's not always actionable. It's not always creating liability. But in this case, Google, by failing to act, didn't necessarily create new liability, but they incorporated themselves in the potentially unlawful acts of others, right? By failing to stop their managers, it makes it look like there's a rule or a policy that supports the manager's decisions. So Google had a chance to separate themselves from the actions of their managers, to discipline them, reprimand them, potentially terminate them, and they didn't do so. So that failure to act is a problem. Google's conduct was a substantial factor in causing the harm. I think that's pretty obvious. And then copy pasta. We want everything. Fifth cause of action, and after this one, I'm gonna wrap it up, and then tomorrow I will do the sixth cause of action, and I'm looking to do a live stream Friday at 10:30 p.m. Central Time. So if you've made it this far in the video, kudos and congratulations. Friday will be an open forum Q&A, mostly focused on the Google suit, but I will be happy to be distracted in other ways. 10:30 p.m. Central Time. Please, it'll be on YouTube. Any of my sort of communication methods that are out there, I will be posting, a notice once I solidify that time. 99% sure that's going to be a good time. But check Patreon, check my social messenger or my social messaging on Facebook, on Twitter, on Gab, on Minds, all that stuff. Check me out everywhere. Like it on everything. Follow me everywhere. I don't care. Actually, I do care. Please do. That'd be great. Anyway, I'll communicate the time once it's locked down sometime tomorrow. But yeah, 10:30 p.m. Central, Friday night. That's what it looks like. That'll be on the 26th of 2018. Of January 2018. I'm babbling. Fifth cause of action, retaliation in violation of the Fair Employment Housing Act. California Government Code Section 12940H provides that it is unlawful for any employer or person to discriminate against any person because the person has opposed any practices forbidden under the Fair Employment and Housing Act. Government Code, 12940 et sec. Plaintiffs opposed Google's unlawful hiring and promoting practices in violation of California Government Code by complaining to their supervisors and Google HR on several occasions, which are documented. And the best part, all of this is documented. All of it. Because Google documents and keeps everything. They provide a giant social network that could be part of a lawsuit at any moment. Great. Just terrible, terrible lack of foresight there. Specifically, plaintiffs reported to Google numerous occasions of hostile comments made by coworkers regarding the plaintiff's gender and or race. Oh, excuse me. Plaintiffs further complained regarding the unlawful hiring and promoting practices taking place at Google. In retaliation for objecting to such unlawful conduct in violation of FEHA, Google took adverse employment action against plaintiffs by issuing them verbal and written warnings and by providing them with decreased performance reviews. There's a causal link between plaintiffs complaining to report Google's illegal activities, harassment, discrimination, the subsequent retaliation. This is a conclusory statement, but the question will be, have they laid out a factual basis to show that causal link? In fairness to the argument, I don't know that they've done it. I assume that that is true. My biases, my read of this case makes me assume that this line is correct. However, I don't know if they've sufficiently met their burden to do so. Again, they don't really have to here. They just have to survive summary judgment and lay out their claims. Discovery is where they'll round out all this stuff. But I think they maybe could have done, I don't know how, but I feel like, this causal link is there, but I worry that they haven't laid it out well enough. But we'll see, we'll see. Again, I think they have, but in fairness to the argument, I think that's a potential weakness on this cause of action. Let me be clear. First and second cause of action are damning for Google. And even the third and fourth are pretty bad. This fifth one, this might be the weakest of the bunch. And that's kind of what you do, right? Your strongest stuff goes first. Second strongest stuff probably goes last. And then you have decreasing strength meeting in the middle at the weakest claim. It's a nice way to sandwich in some weak stuff between a bunch of strong stuff, so maybe they forget the weak stuff as they go through. And it doesn't matter if they win on all of these or causes of action. They really only have to win on one for it to be just devastating. Okay. And so retaliating against plaintiffs, Google violated the Fair Employment and Housing Act, among other statutes in California common law. As a direct and proximate result, copy pasta again. Long and short, they want everything. They want damages. They want compensatory damages, economic loss. They want pain and suffering, emotional distress. They want attorney's fees. They want punitive damages. They want Google to pay the max. In the complaint, this is what you do, whether you expect to win that way or not. The idea is to show Google all of the ways in which they could lose if you're going for a settlement. I'm not sure if Damore is going for a settlement. If he is, if he survives summary judgment, man, I think he's got a multi-million-dollar settlement coming. And the class has a separate multi-million-dollar settlement coming. It's hard to say. And he may take it, he may not. If he's going on principle, he may not take it. But I almost think that even if he is taking a principled approach, if he gets offered $10 million, take it. Do a startup. Run a conservative version of Google. You've got the knowledge. You've got the employee base. You could go after those guys. Create something that that the market wants, and do it in a smart way. Maybe that's the best move for him. I don't know. I'm not him. I'm not his financial planner. I don't care what he does. This lawsuit is interesting because it takes the bludgeon that has been used against white males and it flips it. And it starts to act in favor of white males. And, don't mistake me, right? Don't mistake me for thinking that, or don't mistake me for a white nationalist or an ethnocentrist. I don't care. I really don't. I grew up, the area I started going to school in, I was a minority. I grew up in Houston, Texas, at first, for the first formative years of my life. And white kids were absolutely a minority in the school I went to, and that's fine. I never felt out of correction. Felt a little out of place. A lot of that had to do with me being a small child, and some of those kids having a much rougher upbringing than I had, and being engaged in violence as a matter of course. That's fine. Other than that, being around various genders and various races doesn't bother me. It was part of my upbringing. It was actually kind of a culture shock moving to Minnesota and the area that I did, because it was so limited in diversity. I don't think diversity is a special thing. I don't think it's some sort of sacred cow that needs to be protected. I get it. I don't want people to be discriminated against based on any of their particular features. Again, do you make me money or do you cost me money? That's what ultimately should matter, because it's America, and America is built on business. Okay? So don't mistake me for making like an ethno-nationalist or ethnocentric argument. It's not what I'm doing here. The ideal result for any law is that if it's used as a bludgeon against some particular category, that they can similarly use the law as a bludgeon when they are wronged. That's the outcome, because that is the spirit of the 14th Amendment. Equal protection under the law for all people. If we don't have it, if we have an unequal protection, we're violating the 14th Amendment. Even if that unequal protection is giving special rights, special privileges, or special ammunition to an underrepresented minority. I'm sorry, no matter how much you want an underrepresented minority to have greater representation, like at the Oscars or whatever, you can't do it at the expense of another person based on some protected category. Like if they're white, or if they're male, or if they're right-leaning, or if they're heterosexual, or homosexual, or transgender, or specifically opposed to being the idea of transgenderism. It doesn't matter. If the bludgeon is used in one way against employers by a protected group, it should similarly be used by every protected group. And protected groups include privileged groups. Like, you may not think they need the protection, but they get it because of the 14th Amendment. And that's a good thing, because at some point, privilege can and will ultimately shift. And we don't want the periods between privilege and non-privilege to be marred by bad decisions. We had that happen. It unfortunately happened in the period between emancipation and 1964 and 1967, I guess, the civil rights movement, right? Like, we had 100 years of transition in which courts, the Supreme Courts, the legislatures ultimately made discriminatory decisions, flying in the face of the ideas espoused by the 13th and 14th Amendments. We don't want that to happen anymore. I'm sorry that it happened to a group of people who are all dead, by the way. Correction. Many people lived through the civil rights movement. I'm talking specifically about slavery and people who were alive during the enactment of the 13th and 14th Amendments. Let me be clear, because I'm a lawyer. I guess I should be clear. But I'm sorry that it happened to people. I'm sorry that slavery occurred. But no one today was a proponent of slavery, and no one today was a slave under the American slavery system. By the way, enforced and propagated by the government. Just like Jim Crow, let's remember who created laws to prevent people of a certain ethnicity from eating in diners with white people. It was the government. But we have made big strides to correct those wrongs. But in doing so, during the transition period, we had bad decisions made by courts. We had bad laws made by legislatures. The idea is that we learn from that mistake, and we don't decide that other races need to be punished similarly because one group of people had it bad off. We hope that no one has it bad off a second time. That's the ideal. Not that other people have to have it bad off because one group had it bad off. So anyway, I'm rambling now. The point I'm making in all this is that it's a good thing that a privileged class can use the same law as an underprivileged class to protect their rights. Because ultimately, at the end of the day, we're concerned with protecting people's rights. Because rights matter. And if you think that rights don't matter, go to Singapore and watch South Park and then go to jail. If you think speech doesn't matter, go watch a TV show that's not on the approved list in Singapore and go to jail. Then tell me rights don't matter. Anyway, thanks for watching, guys. I'm going to stop rambling on. It's really late. I'm really tired. Tomorrow night, I will go through the 6th, 7th, 8th, 9th, and 10th causes of action with some citations, hopefully, and brought to you by Tess Lynch, who has provided me with the citations. Don't let me disparage her name, but she's helped me out with some of the research on this. I'm more saying that hopefully I will faithfully deliver some of her research to you guys in a compelling and competent manner. Thank you. Please watch the next video, and then please, most importantly, join me for the live stream on Friday. Ask your questions. It'll be grand. Thanks, y'all. Have a good night.